Hello everyone. In this presentation, we will see how the principles of tortious liability evolved. The ancient law was only a law of wrongs, and they were not classed under various heads like breach of contract, torts, crimes, etc. Procedure adopted for redressal was the focus rather than the substance of legal rights. Instead of inquiring whether any right of the plaintiff was violated or where there was a breach of duty by the defendant, the question was whether the plaintiff had any form of action against the defendant, and if so, in what form. If the plaintiff could not fit his claim under any form of action that was then existing, his claim would be dismissed. Hence, the English law remedies for wrongs suffered depended on writs. These writs were written orders of king issued by the chancellor or his office, whereby the defendant would be summoned before the court and asked to show cause against plaintiff's complaint. An action could not be brought against the defendant by the plaintiff unless he obtained such writ in his favor by paying a price for it. If the plaintiff purchased a wrong writ or where he could not fit his claim under any of the existing writs, even where his right was violated, he would not be able to redress his grievance. The maxim then was ubi remedium ibi jus, that is, where there is a remedy, there is a right. The writs that were available for redressal of torts were at first writ of trespass and later writ of trespass on the case. Now, what are these writs? Writ of trespass was available for redressing direct and immediate injuries to the person and property, both movable as well as immovable. Where the injury was consequential or indirect, the writ of trespass was not available. Writ of trespass upon the case was developed later to cover injuries which were indirect and consequential and which were to the person and property. If the claim did not fall under these two heads, no relief was available to the injured party, that is the plaintiff. In 1285, the king by an enactment authorized the office of chancery to issue fresh writs of trespass on the case in case of new injuries to meet the needs of the injured person. Throwing a match on another man's stack of hay is trespass because the injury here is direct. Lighting fire on one's own land, which spreads on to the adjoining property, causing loss of property, is actionable only on the case, that is trespass on the case. Hitting a person with a heavy stick is trespass. Placing a log in his way all of a sudden causing him to fall and suffer injury is trespass on the case. In the first case, the injury caused was direct. In the second case, it was indirect or consequential. These forms of action were subsequently abolished, and the pleadings containing only a statement in summary of the material facts on which the party pleading the case relied became sufficient to bring an action for tort. Now, is it law of tort or law of torts? There is a difference of opinion on this also among jurists. According to one theory, which is also called pigeon-hole theory, the number of torts are specific and definite. Beyond these, the liability in torts does not arise. According to this theory, it is law of torts and not law of tort. According to the other theory, all acts that cause injury to others by violating their rights are torts unless there is legal justification for it. Thus, as per this theory, it is law of tort and not law of torts. The first theory is put forth by Salmond, according to which a plaintiff can bring an action against the defendant only for certain specific acts or omissions. Just as law of crimes consists of rules punishing specific offences, law of torts consists of rules providing redressal for specific injuries. When prosecuted for an offence, the prosecution has to prove beyond reasonable doubt that the accused is guilty of the offence. When sued for an alleged tort, the plaintiff has to prove that his case falls within some specific rule of liability. It is not for the accused in a criminal case or the defendant in the civil case to defend himself that his case is within some specific justification or excuse. The propounder of the second theory is Pollock, and it is supported by Winfield. According to this theory, every wrongful act that causes harm to any person in his body, mind, reputation, or property is a tort unless there is some legal justification. The reasons put forth in support of this theory is that there has been a steady increase in the number of torts, and new torts like negligence, deceit, etc. are recognized. According to the editors of Salmon's book on torts, just because it is said that the law of torts consists of torts cabined in pigeonholes, it does not mean that there is scarcity of torts in the pigeonholes and that more torts cannot be added to it. While it is true that the law of tort has developed and is developing, it is also true that with the expansion of tort law, we are heading towards general principles of liability in law of torts. Thank you.